start with the session. So we'll quickly revise what we did in the last session and then we can proceed further. Fine. So in the last session, we have done, we were done with 167 and 169 and 170. Fine. We understood all the dynamics of 169 and 170. When 169, I told you that, see, police officer has the authority to, without producing it before the magistrate, he has the authority to release the accused on bond. Now, one thing I told you that what if the police officer produces before the magistrate, or if he forwards before the magistrate, then for releasing, he will require the permission of magistrate. He cannot so moto release the accused. Under 170, I told you that whenever police officer is filing a charge sheet, in that case, he will have to produce the accused before the magistrate. And if he is not filing the charge, and if he is not producing, then it won't be a major irregularity because it is not an obligation under 170. This is something which we went on to understand while we were dealing with Siddharth versus state of NCT, wherein I told you, sorry, Siddharth versus state of UP, wherein I told you that it is not obligatory. So there may be a situation wherein already bail has been granted. When such a situation arises, you need not take the person in custody and again produce him before the magistrate, because that will be that will result into unnecessary cancellation of bail, which is not allowed. Because cancellation of bail cannot be a routine matter. It has to be only in exceptional cases, and it will only be in cases wherein the accused has absconded or accused is tampering evidence. If accused is not doing any such thing, so just for the routine purposes, you cannot cancel bail. From there, we went on to understand an interesting concept that was known as case diary. So I told you what exactly is case diary. So I told you whenever an investigation starts, police will make a case diary, investigating officer will make a case diary. He will record day-to-day investigation or day-to-day finding in this case diary. Now, what is the purpose of this diary? Purpose of this diary is simple. Purpose itna hi hai, to ensure that the investigation is done fairly. For what is the use of this diary? See, use is twofold. The court will not use it in evidence, but court can use it for calling witnesses. Court can also use it for asking question. Court can also use for contradicting the witnesses. But court will not use such case diary as evidence. Court can also use, the IO can use it for refreshing his memory. These are the three purposes that are there of the case diary. Fine. Then I told you case diary is a paginated record, and it is duly volumed. It will contain the information from where you have started the investigation, from when you have closed the investigation, what statements you have made, what all things you have found during the investigation, and everything will be recorded in the case diary. Fine. Now, one thing I told you that accused cannot have a copy of case diary, because case diary is a privileged document between court and the police officer. So accused will never have a right to obtain case diary. ऐसा कभी नहीं होगा कि accused का हक है कि case diary उसे मिले. It is a privileged document between court and the police officer. So it will never be the right of the accused. तो अभी हमें कुछ चीजें लिखनी है. First is case diary, a privileged document. First is case diary. Today we'll deal with a few cases. So the first thing that we'll deal with is case diary, a privileged document. Now this is privileged under which section? सोचो, guess करो. Case diary, a privileged document. Yes, Samiksha, बताइए.
Good morning, sir. Sir, yesterday we were supposed to write Pulupuri Koteya versus King Emperor 1947 Privy Council judgment.
We'll write that.
Okay.
That only we are writing. That we are only continuing. Under what section it is privileged? Case diary, a privileged document. Case diary, a privileged document.
162.
162 में क्यों कैसे privileged होगा? Yes, Nuri.
So 172.
ना.
167.
ना. Privileged documents कहाँ हैं? तीन चीजें privilege हो सकती है ना? Three things can be privileged. 122, 123 or 124. And last is 126.
122 sir.
It is an official document.
126 तो नहीं है. ये है ना? 124 है. It is an official communication. It is basically an official communication, and it is also an unpublished record. So 123 and 124. So case diary is a privileged document under 123 and 124. It is not under 122. It is not under 126. Indian Evidence Act याद है? IEA. ठीक है, तो that is the reason we are saying case diary is primarily, ये तो नहीं लिखा ना case diary primarily is, ये तो हमने नहीं लिखा है, yes, ठीक है, case diary primarily, case diary is primarily a privileged document, between investigating officers, between investigating officers and the court. ठीक है, investigating officer records day-to-day investigation. Records day-to-day investigation. Day-to-day investigation. Day-to-day investigation proceedings in case diary. In the case diary. In the case diary with date and time of the investigation. With date and time of the investigation. With date and time of the investigation. With date and time of the investigation, along with details of the investigation. Along with details of investigation. ठीक है. Now comes the purpose of case diary. What exactly, why are we actually making case diary? So basically there are two purposes of case diary. दो ही purpose हैं case diary के. ये लिख लिया?
The previous slide ones.
Yeah.
Done, sir. Thank you.
Have you guys written this? आगे बढ़ूं?
Yes, sir.
Yes.
There are two purposes of case diary. Two basic purposes. One purpose is to create a record. To create a record by investigating authority. To create a record by investigating authority for his own self. To create a record by investigating authority by his own self. By investigating authority for his own self. For his own self. This is the first purpose. अपने लिए ही record create करना. Second purpose is court can examine case diary to find out whether the investigation was done fairly or not. So second purpose is the court can examine case diary. Court can examine case diary. Examine case diary. Case diary to find out whether investigation was done fairly or not. Whether investigation was done fairly or not. Was done fairly or not. Was done fairly or not. Or not. Okay, these are the two purposes. Now comes the mandatory nature of case diary. Is case diary, making of case diary mandatory? The answer is yes. In every case, you will have to make case diary. What will happen if you don't make case diary? See, not making or not recording any entry in the case diary will not per se vitiate the proceedings, but it may raise suspicion by the court upon the investigation. So the court may be suspicious of the investigation, that the investigation probably has not been conducted fairly because this entry is not recorded in case diary or case diary is not maintained. So if case diary is not maintained, the court may raise a suspicion. Now this entire thing, that case diary is mandatory and in every case, there has to be an entry in case diary or in case diary has to be maintained, was held in Pulukuri Kotaiya, and it was also held in that case that if there is no record, it will per se not vitiate the proceedings, but it will allow the court to raise a suspicion that probably the investigation hasn't conducted fairly because they haven't recorded in case diary. Now this entire thing was held in Pulukuri Kotaiya. Pulukuri Kotaiya versus King Emperor. Pulukuri Kotaiya versus King Emperor. Versus King Emperor. This is 1947 Privy Council. Fine. And it was held that it is mandatory. It is mandatory. It is mandatory. Mandatory for the police officer. It is mandatory for the police officer. It is mandatory for the police officer to record the case diary. To record the case diary. To record the case diary. And if he does not, and if he does not record the happening, if he does not record the happening in the case diary, it will not be a material defect. It will not be a material defect. Not be a material defect. Material defect so as to vitiate. So as to vitiate the investigation proceedings. So as to vitiate the investigation proceedings. But the court may raise suspicion. Court may raise suspicion regarding the role of the police officer. Regarding the role of the police officer. And may seek an explanation. From police officer in that regard. ठीक है, तो एक सस्पिशन क्रिएट हो जाएगा अगर आपने नहीं रिकॉर्ड की. The court will start doubting and the court will ask for explanation and you will have to explain that why was this entry not recorded. So ideally it is mandatory, but it does not vitiate proceedings. So it will not be a material defect. It is mandatory, but it will not be a material defect and only a suspicion will be raised. And you will have to explain this discrepancy. Okay, clear? यहाँ तक clear? आगे बढ़े?
Yes, sir.
ठीक. अब evidentiary value of your case diary. So that is already been provided. There is no evidentiary value of case diary. Case diary has no evidentiary value. In fact, it does not have any substantive evidentiary value. So this is something which was held in Niranjan Singh. दो cases हैं इस पे. One is Niranjan Singh and one is Shamsul Kanwar. One is Niranjan Singh. Niranjan Singh versus State of UP. Niranjan Singh versus State of UP. 1957 Supreme Court. Second is Shamsul Kanwar. Shamsul Kanwar versus State of UP. This is 1995. And this is 1995. Fine. अब दो चीजें इसमें held है. Two things are held in this thing. The first thing is that case diary is not a substantive piece of evidence. It can be used for the purpose. IO can use it. IO can use it for refreshing his memory. Okay, IO can use it for refreshing in memory. Court can use it for asking questions. Court can also use it for calling witnesses. Court can also use it for contradiction. So IO can use for refreshing his memory. Court can use it for three purposes: asking questions. Court can use it for calling witnesses. Court can use it for contradiction. तीन चीजों के लिए court use कर रहा है. IO एक चीज के लिए, that is refreshing his memory. So one thing that you have to understand is that case diary does not have substantive evidentiary value. Does not have substantive evidentiary value. Evidentiary value as such. ठीक है. Investigating officer while under examination may refresh his memory on the basis of case diary. ठीक है. अब moreover the court can use, just give me a second, sorry. Moreover, court can use the case diary. Court can use the case diary to ask questions. To ask questions to the IO. To the investigating authority. Okay, to the investigating authority. To the investigating officer. Or to any witness. On the basis of case diary. ठीक है. तो पहला है no substantive evidentiary value. दूसरा है it can be used to refresh his memory. Third, it can be used to ask questions. And then comes the last thing, that you can use him. You can use it for refreshing. You can use it for summoning witnesses as well. So court can also use it. Court can also use case diary. Court can also use case diary. Use case diary for summoning witness. For summoning witnesses for summoning witnesses under section 311 of CrPC. ठीक है. Moreover, further, IO can be contradicted on the basis of further IO investigating officer can be contradicted on the basis of case diary. On the basis of case diary. तो अब इसमें क्या क्या चीजें देखो. No substantive evidentiary value, refreshing memory, ask questions. You can use it for summoning witnesses. You can use it for contradiction of IU, investigating officer. So ये सारे purposes हैं. 1, 2, 3, 4. Fine. These are the 4 things for which your case diary is actually used. ठीक, यहाँ तक clear है? Till here you guys are clear? यहाँ तक clear है?
Yes, sir.
Substantive evidence नहीं है, you can use it for refreshing, asking questions, summoning witness, contradiction of IU. तो पहले तो देखो, तो general rule is not substantive piece of evidence. Case diary not substantive piece of evidence. Substantive evidence, it can be used for the following purposes. So it can be used for, what is the use of this? So first and the most important use is it is used for refreshing memory. पहला है refresh करने के लिए, refresh memory of IU. Second and the most important use is, पहला तो refresh memory of IU. Second is for summoning witnesses. Summoning witnesses under 311. Witnesses under section 311. ठीक है. Then comes, तो पहला refreshing memory है, दूसरा summoning witnesses है. Then comes asking questions. You can use it for asking questions. And then comes, if you are using it for asking questions, can you use it for contradiction? The answer is yes, you can use it for contradiction of IU. These are the purposes of, these are the main elements of this thing, your case diary. Now, one other aspect that you have to understand is, can court compel the IO to refresh his memory? आप उसको force कर रहे हो. Can the court force IO or compel IO to refresh his memory? Now, in this case only it was held that court cannot compel IO to refresh his memory. It is discretion of the IO whether he wants to refresh his memory or not. उनकी इच्छा है. Court cannot compel. Court cannot say that, okay, IO, you are on the stands now, please refresh the memory. That order by the court will be illegal. So it is his discretion whether you want to or you don't want to refresh your memory. So question is, can court compel IO to refresh his memory? On the basis of case diary. ठीक है. So it was held that court cannot compel. The court cannot compel the IO. And that is investigating officer to refresh his memory. On the basis of case diary. Wait a sec. So the court cannot compel IO to refresh his memory on the basis of case diary. refreshing of memory is the discretion of IO. Refreshing of memory is the discretion of IO. Is the discretion of IO. IO की discretion है कि उसको refresh करना है या नहीं. Now one thing is, याद है हमने refreshing of memory में we have done a section, if you guys remember.
159.
हाँ 159 तो किया ही है, 159 तो किया ही है, and we have also done one other section, that is 161 I believe, in which it was clearly provided that if someone is using a particular material to refresh the memory, then the opposite party automatically has a right to examination by using that material. Now, if IO comes into stands and IO has used case diary to refresh his memory, fine. Can now the opposite party use the case diary for cross-examination? Can now the opposite party use the case diary for does accused has the right over case diary? Can opposite party use the case diary to cross-examine?
No, sir.
So
No, sir.
whether accused has a right to use case diary for cross-examination. क्यों नो बोल रहे हो? सेक्शन में तो लिखा है ना, हो सकता है 161 में लिखा है. Section 161 of Indian Evidence Act says that you can use, if a particular person has refreshed his memory through a material, you can use that material to cross-examine. Fine. Privileged communication, but he has used to refresh his memory, na? It is privileged communication, but he has already used it to refresh his memory. So, in the interest of justice, you should get the right to cross-examination. Now, उसने तो already use कर दिया. Had it been privileged, if he did not want to use it, he wouldn't have used it for refreshing memory only, but he has used it for refreshing memory. Will you have a right? Can you use the case diary for cross-examination? The answer is yes, you can. अब use कर सकते हो. If the IO has used case diary to refresh his memory, you can use it for cross-examination. Now, this is something which was held in this case only. ये भी इसी केस में था कि एक बार IO ने अगर क्रॉस एग्जामिनेशन के लिए यूज कर लिया तो आप उसको यूज कर सकते हो इसके लिए. So it was held further. ठीक है, तो पहले तो कंपल्शन वाला लिख लिया ना. हाँ, if the IO that is investigating officer does the refreshing of his memory, then the accused gets a right. Then the accused gets a right to cross-examine. And contradict him. On the basis of case diary. Yes, in continuation. ठीक है, अगर आपने if you have used it for refreshing the memory, if IO has used it for, why won't accused have the right to cross-examine? You will have the right to cross-examine for refreshing the memory. You will have the right to cross-examine on the basis of the case diary, na? Because he has already used it for refreshing the memory. ठीक है. Now देखो, certain elements of case diary will be hit by 162, and they cannot be used for any purposes. So those elements will be statements made to police officer. All the statements of witnesses made to police officer will be hit by 162, and they cannot be used for any purposes. ठीक है, because obviously if it is made in case diary, so it is in the course of investigation. उसमें तो कोई दो राय नहीं है, वो तो course of investigation है. Since it is a statement to the police officer, it will be hit by 162. So it cannot be used for any purpose. तो ये एक चीज है कि that the detailed statements of witnesses, detailed statements of witnesses recorded in the case diary, will be subject to 162, will be hit by section 162 of CrPC. ठीक है. अब एक इंटरेस्टिंग सिनेरियो आपको बताता हूं कि यहां तक क्लियर हो? टिल हियर यू गाइस आर क्लियर? ये हो गया, ये सारे दोनों भी केसेस हमारे हो गए. These all things were held in these cases. The first thing, that it is not a substantive piece of evidence. It is used for refreshing memory. It is used for asking questions. It is used for summoning witnesses. It is used for contradiction. Now, once can the court compel refreshing of memory? No, it is a discretion of the IO. Once you have refreshed the memory, the other party will automatically have a right to cross-examination on the basis of case diary. ये सारी चीजें हमने इन दोनों cases में देखी. Now, one important thing that you have to understand is can case diary be handed over to the accused person? देखो, whenever charge sheet is filed, there will be a stage wherein you give documents to the accused. सारे documents आप देते हो, सारे बयान, सब कुछ, everything you give to the accused, so that he can defend himself and he is in a better position to defend himself. Case diary you will not hand over to the accused. Now, why you will not hand over case diary to accused? Because what exactly is case diary? Case diary is personal jottings of the investigating officer. वो personal observation and personal jottings of the investigating officer है, and if it is given to the accused, then it may unnecessarily complicate the trial, because there are some other areas which the investigating authority may have looked. So if we are actually giving case diary, so what the accused can do, accused can question everything which the investigating officer has done, and that will only mislead the trial, and that will not be in the interest of justice. So that is the reason you avoid giving case diary you avoid handing over case diary to the accused. अब ठीक है, case diary तो हम नहीं दे रहे हैं. Can we give the statements that are detailed statements of the witnesses that are recorded in the case diary? Detailed statements of the witnesses are not personal jottings of the police investigating officers ना. जो भी witnesses ने बोला, investigating officer जैसे जैसे investigate किया, जो भी witnesses ने बोला है detailed, और वो जो statements record किए, can we give copy of those statements, not the entire case diary, but only copy of those statements to the police officer, to the accused person? What do you guys think?
Yes, sir.
देखो, दो चीजें हैं आपके पास. एक है केस डायरी क्यों नहीं देते? Because it is a personal jottings. Those are personal jotting. As and when investigating officer proceeds, वो अपनी jottings लिखते जाता है. ठीक है. Now, even in case diary, there will be some statements which will be detailed statements of witnesses. जैसे जैसे witnesses को बुलाया गया, the moment witnesses, you are actually recording the statement of witnesses. जैसे जैसे आपकी investigation होती है. Now, are these personal jottings? The answer is no, not personal jottings. So they can be given. Copy of these can be given. Copy of these statements can be given. Statements can be given. अब देखो, ऐसे केस में क्या करेंगे police officers? They will give you a photocopy of these statements. Obviously they can't give you the entire case diary. तो आपको एक photocopy दे देंगे इस statement की. Fine. They won't give you personal jottings. जहां पर भी personal jottings है, wherever they feel that there are personal jottings, they may hide that part, and they will not give you that, because see, personal jottings is his personal observation about the case. So if we are allowing you to know the personal jottings, then you may complicate the procedure, because you may doubt everything what the investigating officer is doing, and that won't be in interest of justice. तो ये सारी चीज पर्सनल जॉटिंग्स है, इसलिए हम नहीं दे रहे. डिटेल स्टेटमेंट है तो देंगे. This entire thing was held in Mukund Lal versus Union of India, 1988. Supreme Court. Mukund Lal versus Union of India. Mukund Lal versus Union of India, 1988 Supreme Court. (1988) Supreme Court. ठीक है. In this case, it was held that case diary, the case diary is not handed over to the accused, because case diary is personal jottings. Personal jottings of the police officer. Police officer of the day-to-day investigation. And if these jottings are handed over, are handed over to the accused, then he will unnecessarily complicate things by asking questions. जैसे आप लोग करते हो. Unnecessarily complicate things by asking questions on each and every point. On each and every point of case diary. Of the case diary. ठीक है. आप लोग तो पुराने हो गए हो, नए करते हैं. एक्साइटमेंट होती है एक्चुअली, कुछ वो नहीं होता, डाउट्स नहीं होते. इट्स जस्ट स्पर ऑफ द मोमेंट. एक्साइटमेंट होती है कि अरे कोई नया पढ़ा रहा है तो टेस्ट करें या देखें. 4 दिन की चांदनी, मतलब फिर तो वही सेम ही हो जाते हैं. Whatever the other person is saying, ultimately you stop questioning that, you stop dealing with it. जैसा चल रहा है सही चल रहा है अब. ठीक है. क्लियर है ये?
Yes, sir.
ठीक है. So if now comes this is Mukund Lal versus Union of India. Now, what does the court have the power to examine case diary? Can court actually examine the case diary? Means court can actually clearly take hold of case diary, and court can intrinsically test how the case diary is made and what has been done in case diary, and what are the elements that are there in case diary. The answer is yes. Court can actually examine case diary. Now, when the court can examine, जब court को लगता है कि कुछ गड़बड़ है, when there is any discrepancy, so the court has a power to examine the case diary. So if there is any discrepancy in the case diary, if there is any discrepancy, if there is any discrepancy in the case diary, then the court has the power to examine case diary. ठीक है. अब इसमें तो एक चीज है ही नहीं जो मैंने आपको बताई थी. I have told you one thing that is not here in this judgment. I told you that personal jottings, case diary may contain personal jottings also. Case diary may contain detailed statement of witnesses also. An accused is not entitled to personal jottings. He will never get this personal jottings because he may complicate things. He will ask questions on each and every issue, and that may only result into extension of the trial. So it won't serve any good purpose. But he is entitled to detailed statement that has been made by witnesses. ये तो इसमें नहीं held है. This is in another case, and that case is ये जो चीज थी, he is entitled to detailed investment. This is held in state of NCT. State of NCT of Delhi. NCT of Delhi versus Ravikant Sharma. Ravikant Sharma 2007 Supreme Court. ठीक है. तो accused has a right. The accused has a right to obtain the copy of the statement, of witnesses recorded in detail in the case diary. But he does not have a right to obtain the copy of jottings made by the police officer. ठीक है. अब ये बहुत ही इंटरेस्टिंग है. अब यहाँ से थोड़ा इंटरेस्टिंग सीन हो जाता है. यहाँ तक क्लियर? टिल हियर यू गाइस आर क्लियर? जी ठीक है. अब देखो, this is a case of murder. Fine. And the trial is going for murder. Correct. Now in this murder trial, you are asking the court to hand you over case diary to check what has happened in the investigation. The court denies because there is a clear prohibition under 172 that accused cannot be given case diary. अगर आप 172 में देखोगे लिखा है clearly कि accused shall not have the access to case diary, so court will deny. But what if you are here, you are tried for theft. And you want case diary that is recorded for murder. ये जो murder वाली case diary है, you want this case diary to be used. Will this case diary, will the court allow production of this case diary? Can you produce this case diary? Case diary of another case in totally different case. or
Yes.
prohibition of 172 will apply. देखो, बोलो बोलो बोलो.
So we can use that because it is totally a different matter, and I think there is no problem in that.
Yep, prohibition will not apply here, but there is one prohibition that we studied in the starting. It is still a privileged document. अभी भी तो privileged document है. You will need permission from one person to resolve the entire thing. You will need permission from one person. You can ask for production, but you will need permission from one person. That person will be head of the department. To ensure that it is produced in the correct manner, the court can order production of case diary from another case. But even in that case, you will require the permission of the head of the department because it is a privileged document under 123. So unless the head of the department does not allow its production, it cannot be produced and it can be withheld. So this is one thing that you have to understand. Yes, under section 91, court can ask production of case diary of another case, not of the same case. But the case diary is still privileged. It still has the color of 123. So for that, you will need the permission of head of the department to actually give it in evidence. You cannot give it in evidence without his permission because he is the person who can withhold giving of case diary. So this entire thing was actually held in state of Kerala versus Babu and others 1991 Supreme Court. बहुत सारी चीजें इसमें held की थी. One of the major thing was this. The court can order production under section 91 of CrPC. See, 91 में कोई भी document court can order production of. So court can order production of case diary also under 91. But one thing that you have to keep in mind, that when the court is ordering production, it has to order production of case diary of another case, not of the same case. Second thing, it can order production when the privileged communication it is allowed or privilege is waived off. ठीक है, ये दो चीजों में court can do it. So this entire thing was held in state of Kerala versus Babu and others. State of Kerala versus Babu and others. Babu and others, 1991 Supreme Court. Okay. Now, the prohibition upon the accused, accused against obtaining the copy, against the accused against obtaining a copy of case diary under section 172 lies with respect to the case diary of the same case. Therefore, if he wants to obtain case diary, obtain case diary of another case and wants to contradict the IO and wants to contradict IO on that basis, then such contradiction is not prohibited. Such contradiction is not prohibited under section 172. Rather, the court will issue summon. Rather, court will issue summon. Will issue summon for case diary. For case diary of that other case under section 91 of CrPC. ठीक है? And the IO will hand over such case diary to the accused. ठीक है? Now, the case diary being a privileged document. Case diary being a privileged document. The permission of the departmental head would be required for production. ठीक है? ये है आपका स्टेट ऑफ केरला वर्सेस बाबू. ध्यान क्लियर? यस नूरी, आपका डाउट था, पूछिए.
So, is the accused same here for theft and for murder?
Not necessary. अलग भी हो सकते हैं, सेम भी हो सकते हैं. कोई
Any accused can ask for anyone's else.
हाँ, anyone's this if it is necessary for his case.
Okay, sir.
मान
Sir,
लो किसी
and-
पुलिस ऑफिसर के ऊपर चार्जेस हैं कि he has been tampering evidence. पिछले केस में उसने मतलब he has been purposely implicating people of minority community. So fabricate कर रहा है evidence. So you can जो भी investigation उसने की थी पहले, you can ask for case diaries of all the investigations. So even though those investigations were not against you, but they are relevant for the purpose of this trial. ठीक है? क्योंकि आप actually prove कर रहे हो ना कि the investigating authority itself is biased. Fine.
Yes, sir. So, head would be so last line.
Head of the departmental head of the department. It can be
Would be-
IG also. It can be DIG also.
So,
head of the
मतलब last line क्या है? Department head would be.
Permission of departmental head would be required for production.
Okay, sir. Sir, here the accused meaning the accused or the counsel of the accused.
Accused ना मतलब prohibition accused के ऊपर है. Counsel of the accused भी वही हो गया ना. Charge accused को थोड़े कर रहे हो. Counsel of the accused मतलब sorry charge accused को कर रहे हो. Counsel of the accused को थोड़े कर रहे हो.
Okay, sir.
Accused
Sir
की-
तो accused ही मांगेगा.
हाँ accused ही मांगेगा.
But accused को दिया नहीं जाता है sir 172 में.
हाँ मतलब दिया नहीं जाता आपको केस डायरी, बट दूसरे केस का दे सकते हैं.
Okay,
उसी
sir.
केस का
Thank
आपको
you.
केस डायरी नहीं देते. ठीक है. With this we are done with case diary. Now after case diary, there is this most important and mammoth topic, which is known as police report. इसको हम police report बोलेंगे. And here we will understand a lot of aspects. First we will understand. ये मैं आज लिखा देता हूँ, आज हम नहीं करेंगे ये. I'll tell you. This we'll do after Christmas. So आज हम देखेंगे कि I'll tell you what all we'll cover. First we will cover giving of documents, that is what documents are supposed to be given to the accused. So that is something which has been provided in 173 subsection 5(7), and you will read it with 207 and 8. इकट्ठे ही पढ़ेंगे. इसमें कुछ legislative error है. There is one legislative error that is actually pointed out by the Law Commission in 207 and 208 that we will discuss at length. Then we will understand the meaning of police report. Now, I have already told you that there are two kinds of police reports. One is a positive police report. Ek second. I had told you that there are two kinds of police report. One is a positive police report and the other is negative police report. पॉजिटिव पुलिस रिपोर्ट का नाम हम क्या बोलते हैं, बताओ मुझे.
चार्जशीट.
चार्जशीट. और नेगेटिव?
क्लोजर रिपोर्ट.
क्लोजर रिपोर्ट. अब इसके एक ही नाम नहीं है, जैसे बहुत सारे नाम है. चार्जशीट को कई स्टेट्स में आप चालान बोलते हो कि चालान लग गया है इसके अगेंस्ट. तो कई स्टेट्स में आप यहाँ पर चार्जशीट को चालान बोलते हो. क्लोजर रिपोर्ट को कहीं इसमें रिफर्ड चार्जशीट बोलते हो, कहीं उसमें कैंसलेशन रिपोर्ट बोलते हो. So a lot of names are there in various states. So we will discuss them, what exactly these names means and what exactly is the role of a negative police report and what is the role of positive police report. अब यहाँ पर ना डिस्कशन बहुत ही बढ़ जाएगा. We'll understand closure report. अगर आपको किसी को याद होगा, there was this case against Arnab Goswami that was abetment to suicide of a fellow. उसमें क्या हुआ था? A closure report was filed. After filing of the closure report, police conducted further investigation and then they arrested him. तो उसको सुप्रीम कोर्ट से बेल मिली थी. बॉम्बे हाई कोर्ट हैड डिनाइड बेल, अगर आपको याद है तो. कोविड के टाइम में हुआ था 2020 में. DY Chandrachud had granted bail. So that thing we will discuss, because in that case the concept of closure report was discussed at length. कि closure report का जो essence है वो क्या है? Does it, if I am closing an investigation, am I being prohibited to conduct further investigation? मान लो मैं पुलिस वाला हूँ, मैंने आज इन्वेस्टिगेशन क्लोज कर ली मर्डर की. कल मुझे कोई और आके बोलता है कि साहब ये तो हुआ है, ये ऐसे हुआ है, इसने किया है. So now can I conduct further investigation or is it a nail in the coffin? ये हमें समझना पड़ेगा. These are the two things that we have to understand while we are studying closure report. So actually नाम closure report है, but actually में पूरी तरह से क्लोज नहीं हो रहा किस्सा. आप फिर से इन्वेस्टिगेशन खोल सकते हो. तो ये मत बोलना कि सर नाम क्लोजर रिपोर्ट है तो बंद ही हो गया है. ऐसा नहीं है मामला. कोई भी चीज नहीं आ गई वो वापस खोल सकता है. He has that authority. Then we will understand the difference. Then we will understand something known as preliminary charge sheet. बोलते हैं, पिक्चरों में सुना होगा कि you file preliminary charge sheet. You file preliminary charge sheet. प्रिलिमिनरी चार्जशीट आप फाइल कर लो, फिर हम देखेंगे कि क्या करना है, कैसे करना है. You just file a preliminary charge sheet. So we will understand what exactly is preliminary charge sheet. Basically, preliminary charge sheet is similar to status report. हर 15 दिन बाद इन्वेस्टिगेशन जैसे जैसे चलती रहती है, after every 15 days you give status to the magistrate कि boss, this is what I have found in investigation, this is what I am doing. Every 15 days you give. And then comes occurrence report. The difference between occurrence report, then we will understand the difference between occurrence report, remand report and police report. तीनों के बीच में डिफरेंस क्या है? तो बेसिक डिफरेंस है, कुछ है नहीं. मतलब इसमें तीनों में ये स्टार्ट, ये एंड के लिए और ये रिमांड करने के लिए, सिर्फ इतना ही है. That is the difference. And then comes the most striking question that is often asked in exams. Is judicial magistrate bound by police report? मान लो पुलिस वाले ने बोला कि offense has not been committed. Are you bound by his statement or you can apply your mind and take cognizance accordingly? किसी को याद हो तो हमने आरुषि केस किया था स्टार्टिंग में. I told you that
Yes, sir.
even
He is
on
not bound.
he is not bound. Even on closure report you can take cognizance. So magistrate is not bound by a police report. You can take cognizance even on closure report. कोई उसमें चिंता की बात नहीं है. Then we will understand a beautiful concept of protest petition. Suppose मान लो the police officers have filed a closure report. You are not happy with that closure report and you want to file a protest petition. You are protesting that closure report. You are saying that more investigation needs to be commenced. More investigation needs to be done. So in that case, you will file a protest petition. what all are the elements of protest petition and how the court will decide protest petition. And if court decides in favor of protest petition, how the court will take cognizance. So that we will understand here. तो दूसरा है supplementary charge sheet. अब देखो यहाँ पर ये दोनों में कंफ्यूज मत होना. प्रिलिमिनरी मतलब स्टेटस रिपोर्ट है हर 15 दिन. सप्लीमेंट्री मतलब सबने एग्जाम दिया है, वी ऑल हैव गिवन पेपर्स, हम एक चीज लेते हैं, सप्लीमेंट लेते हैं. सप्लीमेंट कब लेते हैं? जब मेन पेपर, कब लेते हो? जब मेन पेपर
फेल हो जाए,
भर जाएगा तब एक ऐड करने के लिए सप्लीमेंट लेते हो ना. सेम गोज विद सप्लीमेंट्री चार्ज शीट. Once you have filed the original charge sheet and you still want to continue the investigation, आपने original charge sheet file कर दिया, but you still want to continue the investigation, and further investigation you still want to continue, and in that case you will file a supplementary charge sheet. तो ये है further investigation के दौरान आप supplementary charge sheet file करते हो. ठीक है. तो कभी भी ये मत confuse होना कि preliminary और charge sheet और supplementary charge sheet same है. नहीं, word समझो ना. Look at the word supplement. आप supplement कब लेते हो? When the original paper is complete. So even in this case, when the original charge sheet is complete and you have already filed, magistrate has taken the cognizance, you are still continuing the investigation because you want to find something new. So once you have find something new, you will have to give that to the magistrate, na? So for giving that to magistrate, you will file a supplementary charge sheet. Fine. And then comes the last thing, difference between पहले तो री इन्वेस्टिगेशन, कॉन्सेप्ट ऑफ री इन्वेस्टिगेशन, इसको डिनोवो इन्वेस्टिगेशन बोलते हैं. एंड हु कैन ऑर्डर री इन्वेस्टिगेशन और डिनोवो इन्वेस्टिगेशन. डिनोवो मतलब पूरा इन्वेस्टिगेशन फिर से करो जीरो से. ठीक है, जो भी तुमने किया है, वी आर नॉट इन अग्रीमेंट ऑफ व्हाटएवर इन्वेस्टिगेशन यू हैव डन, स्टार्ट फ्रॉम द बिगिनिंग. सो दैट इज री इन्वेस्टिगेशन. And what courts can order, that we will understand. And then comes the last concept of further investigation. And can magistrate order further investigation? That is one other question. Can magistrate order further investigation even after taking cognizance? Order further investigation. तो ये भी समझेंगे हम. Investigation. तो ये सारी चीजें हम इसमें समझेंगे 173 में. ठीक है. इसके साथ हमारा इन्वेस्टिगेशन का जो मेन पोर्शन है वो एंड हो जाएगा. टिल हियर यू गाइस आर क्लियर? यहाँ तक क्लियर हो?
Yes, sir.
Yes, sir.
ठीक है, चलिए इसको क्रिसमस के बाद करते हैं. लेट्स डू इट ऑन 26th. सर कैन यू प्लीज शो द स्लाइड्स ऑफ निरंजन सिंह? I wasn't. Yes sir. So in conclusion, can we say that although the case diary is a privileged document between IO, between court and the IO, in case where the IO has used it for memory refreshment, then the defense will... Yes, true. You can say that. You can say that. Niranjan Singh, this one, this slide.
Yes, sir. Post this slide.
Post it after this one also, no?
Yes, sir.
ठीक है. Merry Christmas everyone. Enjoy the weekend. Enjoy Christmas. 26 से आपसे मुलाकात होती है. Yes, Navamita.
Sir, I have a confusion on section 170 and the case Siddharth.
Siddharth versus State of UP.
Sir, in that case, it talks about cancellation. I mean, the bail won't be cancelled.
Yeah.
Only that thing.
Bail won't
And-
be cancelled.
Just for, I mean, filing of.
Just
I mean, the
because
report.
charge sheet has been filed, we will not take him in custody for production purposes. So that is not obligatory.
And sir, section 170 talks about that the accused will have to be produced.
Accused will have to be produced, but it was held in Siddharth that it is not obligatory. If a person is not in custody, just for the purpose of production, you will not cancel his bail. That is what it was held.
Okay. And it is only when there is sufficient evidence against him.
Correct.
Okay.
Then
And
only
if there is. Okay, sir.
then
And when there is no sufficient evidence against him, then section 169 will come.
correct.
Okay, sir.
Then 169 or 167, as the case may be. मतलब
This is for further
for further
investigation could not be completed within 24 hours.
correct. Chalo. Bye everyone. See you guys on Monday. Enjoy the weekend. Chalo.
So will we have the evidence class tomorrow?
I'll let you know the timing. See, evening में मेरी एक और class है. If I will have in the afternoon.
So
Afternoon.
we have been provided the timing. I think some 4 o'clock.
They have provided 4 o'clock. Then
I think it is 4. I posted on the group.
I'll check it, and then you will have the class.
Tomorrow we will have.
Yeah, if they have given the timing, then you will have.
Okay, sir.
Fine. Chalo. Bye everyone.